Good morning, everybody, and welcome to Coffee with Craig, where we talk all things Second Amendment advocacy, firearms policy, you name it. We try to bring to them a little bit of what I like to call uncommon sense, because as we all know, common sense is not that common. In fact, coming out of most of these legislators, you're hearing a lot of common nonsense. So anyway, that'll be a big part of our discussion today, which, coming out of California, you hear a lot of common nonsense. But before we get into our discussion, I want to remind you to please like and share this video so that your friends can join into the conversation. Also want to encourage you to please subscribe to our YouTube channel and follow us on Facebook so that you can get alerts whenever we go live. And by the way, on YouTube, you got to make sure you hit the little bell so that, once again, you get those alerts when we go live. Once again, so you can be a part of the conversation live when it is actually happening. Also want to remind you, FPC Gear is open, fpcgear.com. That's fpcgear.com. Here you got a chance to buy cool T-shirts, whether it's our gun rights T-shirt, whether it's our Gadsden flag T-shirt for men or women, or it's our gun rights T-shirt or Right to Bear Arms T-shirt. Whichever one it is, you get a chance to buy a cool T-shirt, look good, as well as support the cause. Every dollar you spend comes right back into the fight for our constitutional right to keep and bear arms. So let's get into today's topic, talking about common nonsense. You guys are all aware that gun violence restraining orders, or extreme risk protection orders as they're called in other states, have become all the rage. California has them, and now everybody else wants to institute one. These are basically restraining orders where someone in your family, at least in California, someone from your family or law enforcement can go to court in an ex parte hearing, meaning you don't get to be there, you don't know about it, and they can have your gun rights taken away. And then with that is issued a firearm seizure warrant. Law enforcement comes to your home and says, we're taking your guns. And you lose your gun rights. You don't even get a chance to defend yourself until 21 days later. 21 days later, you finally get your day in court, and now you are guilty until proven innocent, where you have to go into court and prove that you are not a danger to yourself or others. Now, that is my explanation of gun violence restraining orders. This bill in particular by Mr. Phil Ting out of the Bay Area, he wants to expand this bill to include coworkers, anybody you work with. It doesn't matter how big a company you may work with or work for. He wants to expand to include coworkers as well as teachers and instructors and school employees who may have dealt with you in the last 6 months. So let's let Mr. Ting explain, one, what he believes a gun violence restraining order is, and why, and what his bill does, and why he believes it's a good bill.
The gun violence restraining order is a very simple idea that modeled after domestic violence restraining orders, that you can go to court if you believe someone is a danger, should not have a gun. It allows people currently in law that if you're a family member and if you're a current law enforcement official, to be able to go to court and have that happen. Unfortunately, since then, we've seen numerous shootings occur, like the one on Friday, unfortunately, at schools. People who clearly knew that a student was potentially a person who shouldn't have a gun or shouldn't have access to a gun would have been able to help. We saw that kind of situation that potentially could have happened in Parkland. In Parkland, we had an individual who clearly the principal knew, the teachers knew they could have used this type of gun violence restraining order. We also see it in instances around coworkers. So that's why we want to have the intention of expanding it to coworkers, employers, as well as people, school administrators, teachers, faculty, professors.
Hey, all right, so this is wrong in just so many different ways. First of all, they clearly are operating under the Rahm Manual plan of crisis management, and that is never let a good tragedy go to waste. By claiming that the shooting that took place in Santa Fe, Texas, by trying to claim that that is something that could have been stopped if this had been in place, by trying to claim that Parkland is something that could have been stopped. Now, you think it's just this guy? No, he's not the only one. Check it out.
But today, again, on the heels of what unfortunately happened in Texas, I really do ask that we don't just send thoughts and prayers, but that we do some action. We send some action to students, to families who really are scratching their heads and wondering what we can do to stem the violence in our schools. And with that, I respectfully ask for your vote on AB 2888.
We remember the shooting that took place at Douglas High School in Parkland, Florida, last February. 17 young people were killed. This bill, if it was enacted, certainly would provide an opportunity for those individuals who know individuals who may be suffering from either mental illness or something of that nature to get the kind of help by providing information so that restraining order could in fact be effected so this individual will not have access to guns.
As we just witnessed last Friday, the horrible events at Santa Fe High School in Texas, a repeat of a horror we seem to see almost weekly. These horrifying tragedies all seem to have the same set of circumstances: guns in the hands of those that clearly should not have them. After these tragedies, the stories always emerge that the perpetrator left clues, in some cases clear intent, as to what they planned to do. Neighbors, friends, and relatives step forward with accounts of bizarre behavior on the part of the shooter, clearly revealing what they should have not have had access to guns. We often debate the extent of the Second Amendment on this floor, but this bill doesn't interfere with the legal right to own guns.
Members, enough is enough. How many more school shootings do we need to see before we start passing common sense gun safety laws?
See, now, let's just break this down real quick. Okay, so the shooting that took place in Santa Fe, that took place last Friday, this was a 17-year-old who, by the way, was not legally allowed to own or possess a firearm without his parent there, was not legally able to do so. So explain to me how this bill, how a gun violence restraining order would have prevented this individual from owning or possessing firearms. It wouldn't have. These were not his firearms. It would have done nothing. How about Parkland? All right, let's talk about Parkland. Parkland was brought up by Mr. Gibson. Now, in the case of Parkland, let's be real clear. Local law enforcement knew. Local school officials, including law enforcement on the campus, knew. All of these folks requested that something be done, and nothing was done. In all of these cases, what we're talking about is not a failure of laws. It wasn't like we need more laws. It was a failure of government to enforce the law. But we don't want to talk about that. See, government doesn't enforce the law. And so what's their answer? Well, we must need another law. It is asinine. And what's even worse is the claims that they say will happen, the things that are going to happen as a result of this bill, once again, stuff that is not in the bill.
We must do everything in our power to prevent these events from taking place, whether it be increasing the use of these gun violence restraining orders, to increasing access and funding to early intervention for mental health care services. When we have reached the point in our U.S. history where more children have been killed in school shootings than U.S. service personnel in 2018, we have reached a crisis that must be addressed.
As a dad with a daughter in a public school, I'm especially in support of the provision of this bill that allows for school employees. We've seen, as my colleague Ms. Reyes indicated, that the students know who the problem students are. The employees know who the problem students are. We need to empower them, give them this opportunity to be able to file for these gun restraining orders so that we can take away the guns from the mentally ill and those who present dangers to themselves and others so that we can fight for common sense gun safety at our schools.
We did take out from 2016 mental health professionals. A number of mental health professionals did not want to be included, so we took them out. We heard them.
So let's just be clear here. All right. The one thing that is being noted here, and this was the interesting part about the whole thing. If there's anybody who is qualified to determine whether someone is a threat to themselves or others, one would think it would be a mental health professional. But they're not included. They're the one group. Keep in mind, there has been absolutely no medical, no psychological, no professional determination that an individual is a danger to themselves or others. And by the way, in issuing this, there is no mental health that's provided, no mental health assistance that's provided. There is absolutely nothing. And then you're not even told, well, how do I prove that I am not a danger to myself or others? None of that is in the bill. None of that is in there. It is, I think you, who I may or may not know, is a danger because I say so. So therefore, your rights are now going to be taken away. Your private property is going to be taken away. Your home is going to be searched. Your business is going to be searched. And then you are going to have to go to court and prove that you are not guilty, because you are guilty until proven innocent. You know, all I can say is, thank God that there were some folks who were speaking who had some common sense in this particular discussion.
I don't have an issue with this bill were it not for the fact that it is ex parte in here, meaning that your weapons could be taken away. A judge could decide that without you even being there to share your side of this story. That could take 21 days for you to be able to do that. And that is concerning to me. The comments that were made about the tragedies that have taken place, the school shootings in particular, I think we all agree that it's horrific. But this bill wouldn't have prevented that. When you're talking about minors, particularly in the last school shooting, that young man, not only did he take weapons that were not his own, were not registered to him, he wasn't even old enough to have them. So this type of bill, I think it's inappropriate to use that scenario as the reason for this bill.
Restraining orders are an effective tool. They are an effective tool when they're enforced. In the case of Rancho Tehama, the gunman had a restraining order against him because he had actually fired on his neighbor. And so through the court system already, because of that incident, the DA was able to get a restraining order against him. He turned in one handgun to the local sheriff. But guess what? In the meantime, in the 8 months since he had that restraining order, he got other guns. He actually built his own gun. And he had other guns that he didn't turn in. And nobody bothered to actually go and enforce the restraining order. So let's not stand here and say, oh, if we pass this bill, we're going to stop these things. Because there's one thing we haven't been talking about. It's very important. You have to enforce the restraining orders. We have a program in California that the Department of Justice runs called the APPS program that's supposed to go to individuals who have restraining orders against them because they've committed crimes against people, because they have an actual history of doing violent things, who have serious mental disorders and therefore are on the prohibited persons list. DOJ is supposed to go to their homes and disarm them and take the guns away. They haven't been doing it. And this has been mentioned many, many times over the years I've been here, that we still have this huge backlog with the APPS program. We gave the Department of Justice $20 million to clear it. They still haven't done it.
Members, question to the author.
Without objection.
Mr. Ting, is the American Civil Liberties Union still currently opposed to this bill?
I believe so.
Yes. Thank you. With that, I would just suggest that when the National Rifle Association and when the American Civil Liberties Union both are opposed to something, it's probably something we ought to take a real long look at before we push the green button.
All right. So, you know, I really want to just say how much I appreciate. That was Assemblymember Melendez, Assemblymember Gallagher, and Assemblymember Patterson. All of them brought up very salient points, all things that I've reiterated, that I've talked about. Number one, this would not have stopped, not have stopped what happened in Texas, and for them to use that as the impetus to push the bill is both disingenuous, intellectually dishonest, and just flat out dishonest. The other thing that was pointed out was that, once again, we have laws in place that are supposed to prevent these things, and they're not enforcing the law. No one's talking about the failure of government to enforce the law or to do the things that they're supposed to be doing. And then lastly, you had Assemblyman Patterson, who talked about the fact that the ACLU is, in fact, opposed to this measure. Here, check it out. Here you'll see a list of the folks who both support, and I'll just encourage you to notice that there is no law enforcement, zero law enforcement that is listed there in support of the bill. So I think it's vital that you note that. And then you notice opposition, the American Civil Liberties Union, as well as the Firearms Policy Coalition. Also, it's important to note that the gun owners of California and the National Rifle Association were there, and they testified in opposition to the bill. They testified in opposition to the bill as well. And I know Dan Reed has been doing a lot of really good work working to try and, because here's the thing. The idea in and of itself of gun violence restraining orders is not a bad idea in terms of, okay, we want to make sure that people who shouldn't have guns don't have guns. But there's got to be due process. And that's been one of the things that Dan has been pushing with every person that he's talked to, that the NRA has been talking about. Once again, it's got to have due process. And the challenge here is this bill does not have due process. Now, they'll say it does. But anytime you take the rights first and then due process comes later, that is not due process, because due process has to be in due time. And due process does not come after you have lost your rights. That, my friends, I am sorry, is not due process. Anyway, as you can see, this debate is raging on. And I'm telling you, this is all about gun confiscation. And they want to expand this program. You see it. They told you. They want to expand this program so that they really want to make it so that anybody can go and have your rights taken away. All they got to do is go to court. And if you've been in California, you know California judiciary is largely anti-gun. The Ninth Circuit, if you go to the federal courts, the Ninth Circuit, which covers California, is largely anti-gun. And they're looking for opportunities. Well, let's put it this way. Many of them are looking for opportunities to take your rights, to take your gun rights. Now, those that aren't are going to err on the side of caution. And they're going to say, well, you know what? We're going to take your rights because, well, hey, guns. That's the direction that they're going to go. And that's why we need to stand up, and that's why we need to fight. We need to stand with Assembly members Melendez and Gallagher and Patterson, and encourage more members to stand up and speak out. Those are the only three who stood up to speak out against this gun confiscation bill. That's exactly what it is, and that's all that it is. No mental determination. No professional has determined that you are a danger to yourself or others. Just some dude. Somebody you may or may not know, thought that you were a danger to yourself or others and decided to take you to court, and an anti-gun judiciary takes your rights. And that, my friends, is how the cookie crumbles in California. So let's fight this bill. Anyway, that's going to be it for today's Coffee with Craig. We thank you guys so much for tuning in. We very much appreciate you guys being a part of the fight for our civil rights. This doesn't happen without you. It doesn't happen without you guys being a part of the fight. So please remember, support the Firearms Policy Coalition. Join at joinfpc.org. Donate at fpc.org. Join the fight for our civil rights, because we have got to use them, or friends, we will most definitely lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.